Hello students, I am Dr. Harpreet Kaur. The topic for the day is ramifications of custodial violence with reference to human rights in India. Introducing the topic, custodial violence is a serious human rights issue in India. It means any criminal conduct by a public employee against a person in custody. It includes torture, ill treatment, and extrajudicial executions by the police. Custodial violence violates the dignity and rights of the person. It also undermines the rule of law and the public trust in the justice system. This lecture will explore the topic of custodial violence in India and its ramification on human rights. It will cover various aspects such as the history, causes, impacts, safeguards, challenges, cases comparison, and creative content related to custodial violence in India. It will also provide some recommendations and suggestions for improving the situation of custodial violence in India and protecting the human rights of the people. Definition and types of custodial violence. According to the Law Commission of India, the crime by a public servant against the arrested or a detained person who is in custody amounts to custodial violence. According to the Chambers Dictionary, the condition of being held by the police, arrest or imprisonment is called custody. Violence means the use of force by one person over another so as to cause injury to him. The injury may be physical, mental or otherwise. Custodial violence basically means torturing or inflicting violence on an individual or group of persons while in the custody of the police or judiciary. According to the National Campaign Against the Torture, that is NCAT, custodial violence is the violence that takes place in judicial and police custody where an individual who has done a crime is tortured mentally or physically. According to International Covenant on Civil and Political Rights, custodial violence is an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercion him for a third person or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Thus, custodial violence includes illegal detention, wrongful arrest, humiliating suspects, extorting information under pressure, and physical, mental and sexual violence. There are three types of custodial violence in India. The first one is physical violence. Physical violence refers to the use of physical force to cause any injury or harm to the person in custody. This is the most common violence used by the public officials. Psychological violence, it deals with the mental aspect of the person in custody. It may involve denying the victim necessities like food, water, sleep or bathroom. The third kind of violence is sexual violence. Any sexual act or attempt of sexual act using violence is known as sexual violence. This includes rape, sodomy, etc. Now coming to the historical background of custodial violence. The historical background of custodial violence with reference to human rights in India can be traced back to the ancient, medieval and modern periods of Indian history. In ancient India, the practice of brutal behavior and severe punishment for criminals were prescribed in various Hindu scriptures such as Vedas, the Manusmritis, the Arthashastras and the Dharmashastras. Torture and violence have been identified with the police in India ever since the Vedic age, that is from 2000 to 1400 BC. Or the barbaric method of torture such as cutting of tongue, pouring of molten hot lead in the ears, throat cutting the limbs, wiping etc. were all known and were part of the law of the land. In the medieval India, especially in pre-Mughal period, the justice system was less intricate and there was no place for individuals' liberty. Severe punishment were inflicted on the criminals and suspect such as amputation, mutilation, branding, flogging, stoning and impalement. But it was Jahangir who interdicted the cutting of noses and ears, but he left other form of untouched amputation. During the Mughal period, the Islamic law of qisas, diya and diyut were applied, which also involved harsh and cruel punishment for certain offences. So far as modern India is concerned, in modern India, the British colonial rule introduced the police system and the criminal procedure code, which gave wide powers and discretion to the police and the magistrates. The police were often used as an instrument of oppression and coercion by the colonial authorities, and they resorted to torture and violence to extract confessions, information and bribes from the natives. The police also faced brutal treatment from their superiors and they developed a culture of corruption and impunity. The Indian Penal Code, the Indian Evidence Act, the Police Act and the Criminal Procedure Code were enacted to curb the tendency of policemen to resort to torture, but they were often ignored or violated by the police and the judiciary. After independence, India adopted a democratic and constitutional system of governance which guaranteed the fundamental rights and the human rights of the citizens. India also ratified various international conventions and treaties on human rights such as Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. However, despite these legal and institutional safeguards, custodial violence continued to persist and increase in India, especially against the marginalized and vulnerable society such as scheduled caste, the scheduled tribes, minorities, the women and the children. The reasons for this include the lack of political will, the poor implementation of laws, the inadequate training and resources of the police, the low accountability and transparency of the police, the delay and denial of justice, and social and economic inequalities and discrimination. Coming to the statutory safeguards for prevention of custodial violence. Section 76 of Code of Criminal Procedure 1973. This section provides that a person arrested by the police must be produced before the nearest magistrate within 24 hours of his arrest, excluding the time necessary for the journey from the place of arrest to the court. This is to ensure that the person is not subjected to illegal detention or torture by the police. Section 176, Clause 1, Subclause A of CRPC 1973. This section mandates a judicial inquiry into incidents of death, disappearance, rapes and other serious incident that occurs within the judicial custody. The inquiry must be conducted by the nearest magistrate empowered to hold inquest, and the report must be sent to the district magistrate or the state government. Section 330 of Indian Penal Code 1860. This section punishes any person who voluntarily causes hurt to extort or confession or any information that may lead to the detection of an offence or misconduct. The punishment is imprisonment for up to 7 years and fine. Section 331 of IPC 1860 punishes any person who voluntarily causes grievous hurt to extort a confession or any information that may lead to the detection of an offence or misconduct. The punishment is imprisonment for up to 10 years and fine. Section 348 of IPC, this section punishes any person who wrongfully confines any person for the purpose of extorting a confession or any information that may lead to the detection of an offence or misconduct. The punishment is imprisonment for up to 3 years and a fine. Section 25 of Indian Evidence Act 1872. This section states that any confession made to a police officer cannot be proved as against a person accused of any offence. Section 26 of Indian Evidence Act 1872. This section states that any confession made by a person while in the custody of a police officer, unless it is made in the immediate presence of magistrate, cannot be proved as against such a person. Section 29 of Police Act 1861. This section empowers the state government to make rules for the regulation, control and discipline of the police force and to prescribe the punishment for the breach of such rules. Coming to the legal and institutional measures. The legal and institutional safeguard and reforms to prevent and combat custodial violence in India are essential to protect the human rights and dignity of the person in custody and to ensure the accountability and transparency of the police and the prison authorities. Some of the legal and institutional safeguards and reforms that have been proposed or implemented in India are ratifying the UN Convention against the torture and enacting a specific laws against the torture. This would oblige India to follow the international standards and norms on preventing and prohibiting torture and other form of custodial violence and to provide effective remedies and reparations for the victims. India has signed but not ratified the convention and does not have a comprehensive law against torture which limits its accountability and credibility on the issue. Setting up independent and impartial mechanism to monitor and oversee places of detention. This would ensure that the conditions and treatments of the persons in custody are in accordance with the human rights and the rule of law, and that any complaints of custodial violence are promptly and properly investigated and addressed. India has some mechanisms such as National Human Rights Commission, the State Human Rights Commission, the National and State Police Complaint Authorities and the Judicial Magistrate. But they face various challenges such as lack of resources, power, autonomy and cooperation from the police and prison authorities. Providing prompt and adequate medical care, legal aid and judicial redress for the victims of custodial violence. This would ensure that the victims of custodial violence have access to medical examination and treatment, legal assistance and representation and judicial remedies and compensation. However, these rights are often denied or delayed due to various factors such as lack of awareness, fear of reprisal, corruption, collusion and indifference of the authorities. Training and sensitizing the police and the prison staff on human rights and the use of force. This would ensure that the police and the prison staff uphold the human dignity and dignity of the persons in their custody and use force and firearms only as a last resort and in accordance with the law and the principles of necessity, proportionality and accountability. However, the police and the prison staff often lack adequate training and sensitization on these issues and resort to torture and violence as a means of interrogation, punishment or extortion. Promoting a culture of respect for human rights and the rule of law among the police, the prison staff and the public at large through education, awareness and dialogue. This would ensure that the police, the prison staff and the public understands and appreciate the value of importance of human rights and the rule of law and reject the use of torture and violence as a method of law enforcement or justice. The media, the civil society and the academia can play a vital role in creating and disseminating such a culture. Encounters in custody. The first case is the Altaf case. This case involved the death of a 24-year-old Altaf in police custody in Uttar Pradesh, Kasganj on November 10, 2021. He had been detained for questioning after a minor Hindu girl went missing. The police claimed he had hanged himself from a pipe in the prison washroom using a drawstring from his hoodie. His family, however, claimed he was murdered. India Today's team visited the police station and found that the pipe that Altaf allegedly hanged himself from was only 2 feet above the ground. Following Altaf's death, 5 cops from Kotwali police station in Kasganj were arrested. The second case is the Thutkukdi case in CBI versus S. Srijit and others. The Honorable Supreme Court held that the death of a father and son, Jayaraj and Benix, in police custody in Tamil Nadu's Thuthukudi on June 23, 2020 amounted to a violation of their right to life under Article 21 of the Constitution, and the police personnel involved were guilty of murder, conspiracy and other offences. They had been arrested for allegedly violating the COVID-19 lockdown rules by keeping their mobile phone shop open beyond the permitted time. They were allegedly tortured and sexually assaulted by the police, resulting in several injuries and bleeding. They died in the hospital within hours of each other. The case sparked widespread outrage and protest across the country. The CBI took over the investigation and filed a charge sheet against 10 police personnel for murder, conspiracy and other offence. This case involved the death of a 59-year-old man, Mahindran, in police custody in Tamil Nadu's Sattakulam on June 28, 2020. He had been arrested for allegedly abusing a police officer who had stopped him for not wearing a helmet while riding a bike. He was allegedly beaten and tortured by the police, resulting in multiple injuries and internal bleeding. He died in a hospital the next day. The case came to the light after Thutkudi case which had occurred in the same district. The Madras High Court took suo motu cognizance of the case and ordered a judicial inquiry. The next case is the Hyderabad rape case. The police killed all 4 suspects of the gang rape and murder of a veterinary doctor in Hyderabad in an encounter on December 6, 2019, claiming that they tried to escape and attack the police with snatched weapons. The encounter was praised by some as a swift justice, but also criticized by others as an extrajudicial execution. The Supreme Court appointed a commission to investigate the encounter. In 2022, the commission concluded that the encounter was staged and the suspects were deliberately killed by the police. The next case in the line is the Ishrat Jahan encounter case. This case involved the killing of 4 people, including a 19-year-old girl named Ishrat Jahan by the Gujarat police on June 15, 2004 in Ahmedabad. The police claimed that they were terrorists belonging to the LET group who were planning to assassinate the then Chief Minister of Gujarat Narendra Modi. However, the Central Bureau of Investigation found that the encounter was staged and that the victims were killed in a cold blood. The CBI filed a charge sheet against 7 police officers and 4 Intelligence Bureau officials for the murder, conspiracy and other offences. The next case in the line is the Sohrabuddin Sheikh encounter case. This case involved killing of Sohrabuddin Sheikh, his wife Kausar B and his associate Tulsi Ram Prajapati by the Gujarat and Rajasthan police in 2005 and 2006. The police claimed that Sohrabuddin was a gangster and an LET operative who was involved in various crimes and terrorist activity. However, the CBI found that the encounter was fake and that the victims were abducted, tortured and killed by the police. The CBI filed a charge sheet against 38 accused, including Amit Shah, the then Home Minister of Gujarat, and several senior police officers for murder, kidnapping, extortion and other offences. The Batla House encounter case. This case involved the killing of two suspected Indian Mujahideen terrorists and the arrest of one by the Delhi police on September 19, 2008 in Batla House, Delhi. The police claimed that they were involved in the serial bomb blast that took place in Delhi on September 13, 2008, which killed 26 people and injured over 100. However, the encounter was questioned by various political parties, human rights groups and civil society activists who alleged that it was fake and that the victims were innocent students. The National Human Rights Commission conducted an inquiry and gave a clean chit to the police, stating that the encounter was genuine and the police acted in self-defense. Coming to the guidelines of the Honorable Supreme Court on custodial violence. In the landmark case of D.K. Basu versus State of West Bengal, 11 guidelines on custodial violence were issued by the Honorable Supreme Court of India to prevent and curb the torture and abuse of persons in police custody or lockups. The guidelines are as follows. Number 1. The police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible and clear identification and name tags with their designation. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in the register. Second, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall contain the time and date of arrest. Third, a person who has been arrested or detained and is being held in custody in a police station or interrogation center or other lockup shall be entitled to have one friend or relative or other person known to him or having interest in his welfare being informed as soon as practicable that he has been arrested and is being detained at the particular place, unless the attesting witness of the memo of arrest is himself such a friend or a relative of the arrestee. Fourth, the time, place of the arrest and the venue of the custody of an arrestee must be notified by the police, where the next friend or relative of the arrestee lives outside the district or town through the legal aid organization in the district and the police station of the area concerned telegraphically within a period of 8 to 12 hours after the arrest. Fifth, the person arrested must be made aware of his right to have someone informed of his arrest or detention as soon as he is put under the arrest or is detained. Sixth, an entry must be made in the diary at the place of detention regarding the arrest of the person, which shall also disclose the name of the next friend of the person who has been informed of the arrest and the names and particulars of the police official in whose custody the arrestee is. Seventh, the arrestee should, where he so requests, be also examined at the time of his arrest, and the major and minor injuries, if any present on his or her body, must be recorded at that time. The inspection memo must be signed both by the arrestee and the police officer effecting the arrest and its copy provided to the arrestee. The arrestee should be subjected to a medical examination by a trained doctor every 48 hours during his detention in custody by a doctor on the panel of approved doctors appointed by Director Health Services of the concerned state or union territory. Director Health Services should prepare such a panel for all tehsils and districts as well. Ninth, copies of all the documents including the memo of arrest referred to above should be sent to the magistrate of his record. The arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. And the last, the police control room should be provided at all district and state headquarters where information regarding the arrest and the place of custody of the arrestee shall be communicated by the officers causing the arrest within 12 hours of effecting the arrest, and at the police control room it should be displayed on a conspicuous notice board. In case of Sheila Barse versus State of Maharashtra, AIR 1983, Supreme Court, page number 378, the Supreme Court directed the state government to take immediate and effective steps to prevent the custodial rape and torture of women prisoners and to provide legal aid, medical care and compensation to the victim. The Supreme Court also laid down certain guidelines for the protection of women prisoners, such as the presence of a female police officer during the arrest and interrogation, the separation of a female lockup from the male lockups, the provision of basic amenities and hygiene in the lockup, and the periodic inspection of the lockups by the judicial magistrate and human rights commissions. In case of Neelabati Behra versus State of Odisha, AIR to 1993, Supreme Court, page number 1960, the Supreme Court held that the death of Suman Behra in police custody amounted to a violation of his right to life under Article 21 of the Constitution, and that the state was liable to pay compensation to his mother for the loss of life and liberty. The Supreme Court also held that the award of compensation in such cases is not a substitute for the criminal prosecution of the offender, but a separate and independent remedy based on the principle of strict liability. In case of Joginder Kumar versus State of UP, AIR 1994 Supreme Court, page number 1349, the Supreme Court held that the arrest of detention of Joginder Kumar was illegal and arbitrary, and that it violated his right to life and personal liberty under Article 21 of the Constitution. The Supreme Court also held that no person can be arrested and detained by the police without a reasonable suspicion or credible information that he has committed or is about to commit a cognizable offence. The Supreme Court also laid down certain guidelines for the exercise of power of arrest and detention by the police, such as the necessity and justification of the arrest, the information of the arrest to the next friend or relatives of the arrestee, the production of the arrestee before the magistrate within 24 hours, and the right of the arrestee to consult a lawyer of his choice. Prakash Singh versus Union of India, AIR 2006, Supreme Court, page number 3172. The Supreme Court held that the police system in India suffers from various problems such as political interference, lack of accountability, inefficiency, corruption and human right violation, and that there is an urgent need for structural and functional reforms to make the police a professional and efficient organization. The Supreme Court issued a set of 7 directives to the central and the state governments to initiate the police reform, such as establishment of a state security commission to ensure the autonomy and accountability of the police, the fixation of a minimum tenure for the police officers, the separation of investigation and law and order functions of the police, the creation of a police establishment board to decide the transfers and promotion of the police officers, the setting up of a police complaints authority to deal with the complaint against the police, the establishment of a National Security Commission to prepare a panel for the appointment of the Director General of Police, and the framing of a new police act to replace the outdated Police Act of 1861. Concluding the topic, I can say that the custodial violence in India is a serious human right issue that needs urgent attention and action from all the stakeholders such as government, the judiciary, the police, the prison authorities, the media, the civil society and the public. Custodial violence in India not only violates the human rights and dignity of the person in custody, but also erodes the rule of law and the public trust in the justice system. Custodial violence in India also has serious and lasting consequences for the victims, their families and the society at large. Therefore, it is imperative that custodial violence in India is prevented and combated effectively and efficiently. I hope this lecture is useful for you. Thank you and have a nice day.